One of the provisions in PNDC Law 284 that appears to have been observed more in breach. Because you hear of many rumors or allegations about 100 Ghana cedis being given to people.
They are facilitating. They are coming to vote.
And you appear that even busing people to the polling station is a form of treating, especially if it is done with the intention of getting them to vote in one way or the other. Right. Unfortunately, I don't think we have paid so much attention to this particular provision, even though it's been in our law since 1992. But many of the things that our political parties do smell and look like treating.
All right. Exactly is that one, and then the one about personation.
Personation, yes. Unauthorized voting is where a person is not entitled to vote. So if you have underage voting, for example, under our laws, you must be 18 years and above to be able to vote. If you have somebody less than 18 voting, then clearly that is unauthorized voting. If you have somebody who is not registered, a registered voter but attempting to vote, that will unauthorized voting. Or it could be that you are a registered voter, you voted already, but then you are trying to engage in double or multiple voting. That also will be unauthorized voting.
Okay.
So any voting or attempt at voting that contravenes the rules on voting would be considered unauthorized voting.
Right. And if you are caught doing this, you should be taken to court. And when you are taken to court, you are looking to paying a fine, if you are found guilty, maximum
of 6,000 Ghana or maximum imprisonment 2 years or both. Or both, and then you'll be disqualified for 5 years.
For being registered.
For being a registered voter.
Okay.
From the expiration of your sentence.
Sentence.
Yes.
Okay. What about the personation? Is it also one common way that people may, infringe the law?
Personation is essentially trying to be somebody that you are not, and that is also one of the problems that we tend to have during voting. You may have people. Somebody look alike, then trying to be somebody who is not. And then the law takes a very serious view of this matter. If you try to present yourself to vote as somebody that you are not, that will constitute personation and the same punishment as for unauthorized voting.
Right.
Again, the law anticipates or expects, requires that if you want to vote on election day, then you have to go to the polling station between the hours of 7 a.m. and 5 p.m. Between 7 a.m. and 5 p.m.
We are not America, so you can't deliver your vote by mail.
No, there's no mail-in vote. There's perhaps what we have, which is similar to that of the Americans, is the absentee vote, but we don't do mail-in votes here. So you have to go and join a queue between 7 a.m. and 5 p.m. And by law, once you are in the queue before 5 p.m., you are entitled to vote.
Right.
Like if you go a minute or a second after 5 p.m., the presiding officer is entitled to prevent you from voting, and we need to note that.
So what is important is that you must make sure that you are in the queue before 5 p.m.
Absolutely.
But if beyond that period, the presiding officer can exercise a discretion to disallow you.
Actually, there is even no issue of discretion here. If you want to just go by the strict test of the law. Right. It is between 7 a.m. and 5 p.m. Once you are a second outside of 5 p.m., you should be prevented.
You are out.
You are out. You are completely out.
All right.
You're welcome back. This is The Law. It's your legal light and help law. Now, today, once again, we're very privileged to have senior lecturer Aziz Bamba to help us understand what the Supreme Court or the judiciary is seeking to do in trying to set some timelines for election disputes, particularly presidential election disputes. They are suggesting or recommending that there will be 7 days within which the petition should be filed. The present situation is that the petition must be filed within 21 days after the declaration of the results. In Kenya, they do it 7 days. And then the whole trial of the case in Kenya takes 14 days. Ghana is saying we want to attempt 42 days. Is that possible? And of course, far better than the 8 long months that it took us to do the 2016 presidential election petition. We'll be right back. You're welcome back. Let's go for our news round. The Supreme Court is recommending 42 days maximum for election disputes that will arise out of the 2020 elections. This is to prevent a repetition of the election petition of 2016, which dragged for 8 long months. Chairperson of the Election Manual Review Committee, Justice Jones Doche, said any suit challenging a presidential election will be allowed from only contestants in the election and the Electoral Commission. Also, Justice Kwesi Enin-Yeboah, the Chief Justice, has indicated the readiness of the judiciary to deal with all election-related suits. The question is, can it be done in the manner that they are seeking or recommending? This is what Senior Law Lecturer Aziz Bamba is going to help us to discuss. Remember that he was part of the historic election petition.
The Supreme Court is proposing that should there be any dispute, it would not go beyond 42 days. And there are major significant changes in the law, in the sense that now if you are interested in pursuing or initiating an presidential election dispute, you must have been a candidate in that election. And you can only sue the one who has been declared as the winner by the EC and the EC. That's all. No political party will be allowed to join the suit. And we propose 30 timelines which will not go beyond 42 days. So these are significant material you find in the content of the manual. What will be the verdict for this manual? Well, the verdict will come from you, the general public, especially the lawyers, our judges, our brothers in the lower court and the other superior courts who will use it, the key stakeholders such as the political parties, civil society groups, the media, election management bodies like the Electoral Commission, CODEO, etc. They will assess whether our work is worthwhile, but we believe it is a good work done.
As we prepare for the 2020 public elections, I wish to assure the good people of Ghana of the thoroughness, the professionalism, and the patriotism with which we approach and dispense our duties. That will never change. Indeed, as part of our preparation for the 2020 elections, our judges had sufficient training to better improve their capacity in handling disputes that might emerge after these elections. Additionally, justices of the Supreme Court have had to travel to various parts of the country to sensitize judges and magistrates in order that they can approach electoral disputes expeditiously. And I'm hopeful that our judges will bring these other skills to bear in the determination of disputes which may arise after the elections.
Right. So in 2012, the election petition took us 8 long months. It was not good because, as we know, it got people on tenterhooks. will we be able to overcome that situation now? Around that time, Kenya had a similar situation, but they had in their 2010 constitution provided for the election disputes, as in presidential election dispute, to be done within 14 days. And they did exactly that. It was said that government had come to a standstill for all of the 8 months when Ghana was in the Supreme Court in 2012 over the disputed election of President John Mahama, until the Supreme Court returned a verdict in his favor. So, as you have heard in the course of the week, the Chief Justice and a committee that has been set up to produce a manual, an election adjudication manual, which is produced every election year by the judiciary, have suggested or recommended that Ghana should also be able to do its election petition for the presidential elections within 42 days. How is that feasible? And that's what we are looking at. Thankfully, we have someone who was part of the election petition of 2012 on the side of the NDC. Dr. Bassett is senior lecturer at the University of Ghana Law School. Thank you so very much once again for making time to be with us.
Something my pleasure.
Great. So just get ready for the education. This is pure law. So in Ghana, presently, presidential election disputes is regulated by CI 74, correct?
That's correct. So regulated by CI 16, as amended by CI
74. Now in CI 74, it repeats Article 64, where it says after the elections have been declared, the petition must come within 21 days. The presidential election petition must come to the court within 21 days. After it gets to the court within 21 days, those who are supposed to respond have 15 days to file their response. After that, some interlocutory matters, the rule says within 10 days will have to be sorted out. Thereafter, the law says the court shall make sure that the hearing goes on expeditiously. It doesn't provide any timeline. But once the trial is over, the judges have 15 days within which to bring the judgments. Where exactly is the problem here that we are trying to solve?
Yeah, Samson, thanks for the issue that you have raised. I think it's a very, very important issue. And the issue that you have raised essentially involves two principles of law. One principle of law is that justice delayed is justice denied. The other principle of law is that the wheels of justice grind slowly. And there are reasons why these two interests are important, because you want to make sure that all the parties in the case have been given the opportunity to present their case to the best of their ability, so that in the end, when judgment is rendered, they won't say they've been shortchanged in terms of process.
Justice delayed, justice denied. But there's the other counter principle that says justice hurried is justice buried.
Absolutely. So these two competing principles are meant to strike a balance between these two principles.
Okay.
Now, in terms of the timeline, maybe I'll just briefly talk about the timelines and then try to show where the issues are and perhaps how we could resolve the issues.
All right.
And in the process, I'll be talking about whether the problem is with the rules or whether the problem is with how the rules have been applied.
Okay.
As you rightly indicated, under Article 64(1) of the Constitution, a person challenging the election of the person elected as president must file a petition within 21 days after the declaration of the results of the president-elect. So 21 days.
Okay.
The Constitution is very, very clear. It doesn't say 7 days, doesn't say 5 days. It says 21 days. So it could be a day after the declaration, but the maximum is 21 days. And because the constitutional provision, it's not possible really to go
around it.
To go around it. It's quite clear. There's nothing unclear about this provision. It's as clear and unambiguous as possible. So 21 days is 21 days. Now, when a petitioner files an election petition by CI 16 as amended by CI 74, the petition is to be served on the respondent. So the respondent could be the Electoral Commission, or it could be the person who has been elected President of the Republic of Ghana.
But the Electoral Commission often will be a constant.
Absolutely.
Okay.
But the rules provide a situation where the petitioner doesn't include the Electoral Commission. Where that happens, the rules require that service of the petition also be done on the Electoral Commission.
Okay.
Now, and by the rules, it appears either the petition is served on the respondents on the same day or maximum within 2 days. Now, if it is not done within 2 days, then the petitioner could go for substituted service for the petition to be served on the respondents in a different mode that a court may prescribe. Now, when the respondents have been served, they have 3 days to file an appearance to show that they have received the petition. Then after the appearance, they have 7 days to file an answer in response to the matters in the petition. After that, essentially what happens is the court within 15 days is supposed to set the rules down for, set the case down for trial. Then there will be hearing, and once hearing completes, then the matter will be adjourned for judgment, and by the rules, the Supreme Court is required to come out with a judgment in 15 days. Now, it appears everything has been designed to ensure expeditious trial. Okay. So you take 21 days plus 3 days plus 7 days. That gives us about 31 days. Then you add 15 days. That gives us 46 days. Okay. Then you add maybe another 15 days for trial. That will give us about maybe close to 61 days. So that looks a bit reasonable. You are thinking of around 61 days before the court even gives a date for judgment. But what happened during the election petition? This has to do with the application of the rules.
No, but was the rule that you are referring to, CI 74, provides for timelines for almost every single activity in the trial of a presidential election petition. When it comes to the hearing of the case itself, it doesn't provide timelines.
Absolutely.
It says the case shall be heard expeditiously.
Absolutely.
So that is where the problem is. That needs cure. And where the suggestion is now coming for 42 days. Is that not so?
Yes, I think you're absolutely right. The rules are very silent on the number of days for hearing. The rules are very silent. So it appears it's left to the discretion of the court. And I think that is one of the problems that we have in terms of the protracted nature of the 2012 election petition. But I also think that, I mean, it's also how the rules have been applied. That is why we had the long delay in the 2012 election petition. And perhaps once we appreciate some of the areas that caused the delay, we should be able to avert the delay in any presidential petition that may arise as a result of the 2020 election. So, for example, in the 2012 presidential election petition, a number of amendments were made to the pleadings. And each time you have amendments, you have to file an application. The other party has to be served. The application has to be moved. Then you have to file the amendment. The other person has to respond. That caused delay. A lot of that, these applications caused delay. You also remember there were a number of applications. Some of them had to do with the composition of the court. There was an objection that was being taken to a member of the panel, but that objection was subsequently withdrawn. There were applications also about joinder, political parties wanting to join the action. The famous amicus curiae brief, somebody coming in basically indicating that the president wasn't the proper person to be sued. There were applications by voters also to join because they wanted to protect their franchise and all. So all these applications, you know, contributed to the delay in the 2012 election petition. Perhaps you could have done things a bit differently. So, for example, if we had, right after the answer had been filed, right, we do a kind of like case management. And then on the case management, we set down what order has been done. We tell the parties, any person who wants to file any application So you file it within this period. Otherwise, you'll not be allowed to do that.
Okay.
We could also have limited the number of days for hearing. You could give the parties maybe 2 days each for the cross-examination. And then after that, the court... After that, then the court will adjourn the matter 15 days and give a judgment within 15 days.
Right.
So I think even under the current rules, it is possible through the exercise of the case management powers of the court for us to be able to cut a lot of the delay.
Okay. So let's get our audiences to get to appreciate the processes a lot better. You are saying that according to the law, from the Constitution and from the rules that have been made, if elections are declared today, the results are declared today, anybody who wants to challenge the results or the declaration has 21 days within which to file the case in courts.
That is correct.
If they don't do that, they lose the opportunity.
They lose the opportunity forever. Yes, and it's any citizen of Ghana.
Right.
So once the EC has published an instrument saying that this person has been elected president of Ghana, then you have 21 days as a citizen of Ghana to bring an election petition.
Right.
Outside of that, you don't have any case.
Now, you say within that 21 days, if the petitioner filed the petition, and the petition is the case that has to be brought to the court, and Dr. Bassett refers to respondents. The respondents are the people you can say are the defendants, those the case is against. Now, once it is given to them, a copy of the case is handed to them, they too have within 15 days to bring their defense, what is known as the response or answer. Now, after they are done with that, you are saying that the period where the law does not provide a particular timeline for the case to be heard, that is the trial, as we saw in the video a while ago, where there were cross-examination, Chachi was asking questions of Dr. Bawumia, and then we heard about, you and I were not there, and so on and so forth. That whole period, the law doesn't give specific time within which you should do it.
It does not.
And that is where the problem is. And that is where we need specific timeline to cure.
Exactly. We need specific timelines to cure. And luckily for us, CI 16, as amended by CI 74, gives the Supreme Court the discretion to actually abridge time.
Okay.
So nothing prevents the Supreme Court, as part of its case management powers, from saying that, look, this hearing is going to take only 5 days.
Okay.
It's going to take only 6 days. Petitioners, I'm giving you 3 days. Respondents, I'm giving you 3 days.
Okay.
And that is it.
All right.
So the Supreme Court can do that. So the current rules allow the Supreme Court. So
but what you noted was that what they cannot change is the time within which to bring the petition.
Absolutely. That one,
which is in the Constitution.
Absolutely.
And actually is in the entrenched provision of the Constitution.
Absolutely.
Which cannot even be amended by Parliament, but must be amended through a referendum.
A referendum, yes.
Okay.
So the 21 days is fixed. It's like the Northern Star. It doesn't move. I mean, nobody can change it. Not even the Supreme Court in the exercise of its interpretive power can change it.
But we have heard the suggestion that they are looking at the opportunity, the possibility of bringing the petition within 7 days.
I think it's a proposal.
Okay.
So I think it's a nice judicial posture.
Okay.
In terms of telling citizens, and I think it's a good thing. Tell citizens that no. Presidential petitions, are key to the governance of a country. Any uncertainty about who is the president can cause chaos and affect our governance. So even though the Constitution is giving you 21 days within which to file your petition, we think that if you do it within 7 days. So I don't think it is a kind of like a mandatory thing that they are saying.
Right.
And as Justice Joche pointed out, it's a proposal.
So you were part of that case. And now, from your experience, we are hearing some lawyers say to require the one who is going to challenge the elections to bring the case within 7 days will not be fair, because elections and the election of a president is a very important matter, and the person needs sufficient time to gather the evidence. Donald Trump has filed how many cases in the US so far?
So many.
They have all been thrown out.
I think that is why the framers of the Constitution, in their wisdom, thought that the 21 days were a good enough period to allow the petitioner to look at the evidence available and decide whether he or she has a good case. And I think we mustn't rush petitioners in going to court, because sometimes initially you would think that you have a case, but after you have slept over, reflected over the matter, then you realize that, oh, what I thought was a good case actually doesn't have any merit. Okay. So I think as much as possible, maybe we should try to maintain or respect the 21-day timeline, because the purpose is to enable a petitioner to be able to adequately consider a matter before deciding to take the radical step of challenging the election of a president.
Right. So if you are just joining us, you are on The Law, and this is your Legal Light and Health Law. We are giving pure legal education about mounting a presidential election petition if you disagree with the results after the results have been declared. In this country, the law provides specific times within which this case must be done. But when it comes to trying the case, as you can watch Philip Addison, the Godfrey Dame by him, and the other lawyers seated around there, they took 8 good months to deal with the case. The Supreme Court is thinking we can cut that down to 42 days. So we are now asking, how is that possible? And we have an example from Kenya where they do that within 14 days. So what will be, are there not potential disadvantages in seeking to set a particular timeline where a presidential election petition must be tried, like we are suggesting 42 days?
I think there are advantages and disadvantages, and whether or not something is a disadvantage that will be to the detriment of a petitioner, it also depends on the background legal rules. Sometimes we could make things very, very easy for ourselves in terms of a decision, the factors that somebody should consider whether to contest a presidential election. So, for example, and you find some of these things in the opinion of Justice Jones Doche. So, for example, if we are to require the Electoral Commission that after elections, all the pink sheets, all the collation reports, and all that should be made available to all political parties, even before the declaration is even done, declaration of president is done. We could do that. Okay. Now, assuming we were to do something like this, what it means is that even before the declaration, political parties will have the opportunity to examine these reports, these results, to determine whether they intend challenging any declaration if it doesn't favor them. So we could use some of the institutional, some legal arrangements to make sure that a petitioner has all the information he or she requires in order to take the decision whether or not to challenge a presidential declaration. Right. So I think that, yes, it could be disadvantageous. For example, if the petitioner, remember the petitioner could just be an ordinary citizen, not a member of a political party. Right. If I'm an ordinary citizen, I want to challenge election, the declaration of somebody as president, where am I going to get the pink sheets? Right. Article 64(1) says a citizen of Ghana. It doesn't say a candidate in the presidential election. Right. And that also goes to one of the issues that Jones Doche raised. Right. The Constitution says a citizen. It doesn't say a candidate in the presidential. So anybody at all could challenge. But where am I going to get the pink sheets to be able to analyze and be able to mount? You realize that in the 2012 petition, there were actually problems with the pink sheets. Absolutely. And the court had reason to observe that some of them looked blurred, faded, ineligible, and so on. Illegible. Now, talking about a citizen brings up the question where Justice Jones Doche, as we just heard him, says that political parties will not be allowed to join the suit. In 2012, NDC was allowed to join the suit.
he says political parties will no longer be allowed to join the suit. What do you say about that?
Well, I think he makes a similar point in his opinion. In the 2013 election petition judgment, where he expressed some reservations about some of the rulings or orders made by the court. And one of them was, look, perhaps we should have allowed the application that required the Electoral Commission, that was asking the Electoral Commission to provide all the pink shares.
Exactly.
Perhaps we should have done that. Again, perhaps we should have denied the application for JoyNews by the NDC. That also needlessly maybe prolonged the matter, I mean, as you saw it.
You know, the editor of the law reports, actually in that report, criticizes some of these decisions.
Absolutely.
And one of his critique was that they denied the application for the pink sheets to be supplied from the Electoral Commission's end. And yet, in the judgment, they had reason to complain about that some of the pink sheets, you know, the quality was bad. So why didn't you allow the EC to bring them? And then the criticism of allowing an inanimate party to be joined, the NDC.
So I think all these are issues, and I think the issues that Judge Jones Oche raises in his opinion are quite germane and relevant. So the issue about whether or not we should allow the joinder of other parties, whether or not we should just limit the petition to the Electoral Commission and then the person who has been elected president and just the petitioner. But I guess it's also the dynamics of the case, because you remember the petitioners were three. It was His Excellency the President, and then we had J. Kotanko Obichebilamte and Bauba. So it looks like 3 against 2. So I guess some of these practical dynamics could have influenced, you know, the application of the motion for joining that. No, but I agree that in election matters, particularly presidential election matters, if there is anything that we could do, I mean, to cut down the number of the parties and just focus on the main issues, I think that will help a great deal in the interest of expedition and having an expeditious trial and subsequently judgment.
Right. And please remember that in this country, a member of parliament, duly elected by the people, went to court to challenge the results. It took 4 years for him to get a favorable judgment. I'm talking about Yawaso West Wuogon, George Amu then, Isaac George Amu then. He won, and somebody was wrongly put there as the MP. By the time he won the case in court, the person who had been put there as the MP had finished serving the term as an MP. So that clearly was a useless exercise in the court.
Is it doable to give ourselves 42 days, knowing the history of how we have done cases in this country?
I think once we have a change in mindset and a change in judicial attitudes, we should be able to do it. But something, I don't have any doubt at all in my mind that with the current rules, whether we are using the High Court rule CI 47 or the Supreme Court rule CI 16 as amended by CI 74, we have enough legal tools within these rules to be able to expedite trial. There is a provision in CI 74 that gives the Supreme Court the mandate to abridge time. So nothing prevents the Supreme Court from saying that even though by the rules, you respondent, you are supposed to file your answer within these number of days. I'm giving you 3 days.
Okay.
I'm giving you 2 days.
Okay.
Or cross-examination is going to be limited to just 2 days per party, and that is it. And the court has done that a number of times.
Right.
If you remember the recent case involving the voters register, the court gave some orders. 3 days, file your statement of case, and within a short time, the court was able to determine the matter. The Supreme Court could do the same. It has the legal tools within the rules to be able to do the same.
All right. And remember also that this discussion is cast against the background of a peace-building process after the elections, so that we don't have trouble on our hands because we are unduly delaying the hearing of a petition
or challenge to election results, you can join us with your questions, and we will have Dr. Bassett answer them right here. So join us with your questions. As you can see, the Zoom ID and passcode have been advertised. The meeting ID and the passcode have been advertised. You can join us and let's have your questions. If you also have some, quick comments about what is being proposed, let's hear them as well. This is the law. And on this show, we just try to give you pure legal education to assist all of us. Now, the judges seem to have expressed some surprise when they were launching the manual. They said election petitions. Many lawyers still make the mistake and they come to the court wrongly. And therefore, that's the reason why they need a manual that will help all lawyers. How can one be wrong in going to the court with a petition, with a case?
Well, I mean, sometimes, I mean, the law is sometimes like a locomotive, right? Once you get onto the rails, you can't go anywhere else.
Right.
And there are rules about how the court should be approached. Without getting into technical stuff, sometimes you approach the court using what is called a writ of summons.
Right.
It's a way to approach the court. Other times, you do what is called origination notice of motion. So some other way of approaching the court.
Right.
They also have a petition. So we use petition for election matters, for presidential election matters and parliamentary election matters. The only instance that we use a petition also maybe in divorce matters.
Right.
But unfortunately, because the writ of summons is the most common form of approaching a court, it becomes the default position for many lawyers, especially those who are not very familiar with election matters.
But it's unforgivable to forget.
But it's completely
I remember in 2016 when there were a number of challenges about the electoral processes. Some people were going to court, they were getting thrown out because they were coming wrongly.
Exactly. Yeah.
Right.
And by our rules, if you approach the court wrongly, especially election matters,
right,
you'll be thrown out.
Okay.
If instead of a petition, you do a writ of summons, you're out.
You'll be thrown out.
And the judiciary has done some analysis showing that quite a number of election petitions were thrown out basically on procedural grounds.
All right.
Because instead of a petition, the parties and their lawyers
came with a writ or something else. All right, and that is where Justice Yoni Kolendi, who spoke about this matter, Justice of the Supreme Court, said, you, the litigant, should also educate yourself. And a manual has been launched by the judiciary. You can access the manual. You can read it. It's reader-friendly. It's not only lawyers who can understand it. You read it, and then you can assist. If your lawyer is not getting it exactly correct, I don't know how you're going to do that, but you may be able to, nudge your lawyer and tell them that this is not the correct way, and they may pay attention so that you don't spend money, go to court only to be thrown out, and maybe by the time you prepare yourself again to return, time has run out and you can't go again. That would be terrible. So if Kenya does it within 14 days for election petition for the president, why are we looking at 42 days?
If I may just maybe place myself into the thinking of those who are making this proposal, I think one is to give sufficient time that will be in compliance with the rules, particularly the mandatory rules.
Okay.
So let's take, as we've been saying, let's take the period for filing presidential petition. The Constitution says 21 days. Nobody can give a different date. So that is it. 21 days, nothing more, nothing less. But then the other timelines are things that the court can control.
Right.
And I think that the court has the power to be able to control other timelines to ensure that at least if you're even going beyond 42 days, it won't take 8 months.
I have a question from Sharif joining us. Sharif, Dr. Abdul Bassett is ready to answer your question. But when we are done, I'd like you to tell us whether you think there's a need for a constitutional approach to it. Like in Kenya. In Kenya, the whole thing is set out in the constitution, so nobody can tinker with it. Hello, Sheriff.
Hello.
Yes. Sheriff, listen to us directly through this. Don't listen to us. Put the volume on your TV off.
Is it better?
Yes, go ahead.
Okay, it's off now. Is it better? Okay, what happens if one wants to challenge all this while we have been talking about the presidential agitations, and I want to challenge the parliamentary? What happens to it? Where do I file to and all of that? Can you address that for me? Thank you very much.
Thank you very much, Sheriff. Okay, so how about parliamentary elections? That's all we are discussing. But how about parliamentary elections? Where do I go to challenge it?
Other one, you go to the High Court.
You go to the High Court.
Done within 21 days.
Same 21 days.
Being gazetted.
All right, and that one, the court seems to say through the case of the Walensee matter that if you are not happy after the High Court, your last resort is to the Court of Appeal. You can't go any further.
Yeah, that is what the court. That is the current state of the law.
All right.
You know, but I mean, creative lawyers can always find ways around.
All right.
It, yes. So from the High Court, you go to the Court of Appeal. Then by the judgment in the Walensee case, you stop there. But sometimes you and I know that apart from the appellate jurisdiction of the Supreme Court, also have the supervisory jurisdiction.
Right.
So a smart lawyer would just say, I'm not appealing, rather I'm actually seeking a judicial review against the decision of the Court of Appeal, and you end up getting the same as an appeal. Yeah. So a smart lawyer can find a way around.
So Sharif, if you want to challenge parliamentary election declaration, then the place to go is the High Court, and the same timelines apply within 21 days after the results have been declared. Who do we have next? Hello, Patrick. Patrick, go ahead.
Yeah, good afternoon, Ghana. I'm New Jersey. Yeah, I think what Supreme Court trying to do is very good in essence that you remember 8 months of going through Supreme Court and the whole country was just torn apart. They didn't know what to do. If Kenya have used 14 days and Ghana want to use 42 days, I think that's a laudable thing we have to support. And in all cases, the Supreme Court have the upper hand of promulgating new laws, right? And then ensure that things done the right. So I support the idea that they set the time frame so that.
Thank you.
Now.
Thank you, Patrick. So you don't have a question, you have only a contribution. If you have a question, please let's have your question. Dr. Bassett is here to address your questions as well. We are talking about presidential election petitions and how the Supreme Court or the judiciary is working to cut down the time of dealing with them. Who is next? Hello, Opoku. Opoku. All right. Opoku, we just lost your line there. You can reconnect. Those of you who have already gotten have the Zoom meeting ID and passcode, just get on board and we will put you on. But remember, always join. And when you are asked to speak, remember to unmute yourself so that we can do things rather very fast. Yeah, so I was asking whether you think we cannot take the Kenyan route where everything is in their constitution. There is a constitution that determines how the petition should be done?
Well, I actually agree with you. I think even though the current rules allow the Supreme Court maybe to abridge time, to extend time, and through that they could control the time frame for election petition, many of these matters require exercise of discretion. Discretion, its exercise could be problematic, especially given our political and sometimes social context.
Okay.
So perhaps in order to bring clarity to these matters, we could just use a legislative approach. And again, let me refer to the opinion of Justice Joche in the election petition. And he made quite a number of suggestions, recommendations, and spoke about the need for us to even amend the rules on election petitions. I'm a bit surprised that it's been over 7 years. It doesn't appear that we have taken the legislative approach. I think we need to do that. That will bring clarity and certain certainty to the entire process.
All right. Okay. Right. This is the law, and we are discussing the proposal by the Supreme Court to cut down the length of time spent on election disputes, particularly the presidential election dispute. 2012, we spent as many as 8 months dealing with that, where elsewhere in Kenya, they spent 14 days dealing with a similar petition challenging the eligibility of the president-elect at the time. And I guess a senior lecturer at the University of Ghana School of Law, the law faculty, and that is Dr. Abdul Basit Bamba. Now, the issue that people seem to have some other concern about is that if you set the timelines in the way that the court is seeking to do, and I feel that I need more time than you are giving me to do, how do I go around it? Because if you limit me to just 42 days, meanwhile, I feel I have so much evidence and I need so much time. And using the example of the suit as in by the NPP, not exactly by the NPP, but as in by the NPP, and they needed so much time to do it.
If we go by prescribed or set time limits, the rules permit a party who needs or requires more time to make a formal application, and then you need to justify it.
Okay.
So the rules permit you to go back to the court and give reasons why time should be extended for you.
Okay.
But the good thing is that it becomes more of the default position is that you do it in 7 days. However, if for good, compelling reasons you want to do it in 10 days, go back and explain to us. And then the court will then consider the reasons that you give in order to determine whether time should be extended or time should not be extended.
Okay, so that's certainly good news. Once you have actual critical need and the time giving is not sufficient, you go to the court and convince the court. If you are convincing enough, they will extend the time a bit for you. Charles, let's hear you.
Yeah, I'm ready. Thank you, Samson. My question is, when you mentioned earlier on concerning the pink sheets that were not printed properly, my question is, I wanted to know if the certified pink sheets can be posted on the website of the EC so that individuals and parties can access it and print copies anytime they have to use it in a court situation.
Thank you very much, Charles. What do you think of Charles's? And I think about his questioning when you stress that the law says a citizen of Ghana can take up the suit. So it must not be a party or person belonging to a political party. And yet your proposal was that one way to fast-track the process is for the EC to make the pink sheets available to the parties.
So I think this should also be extended to citizens, really. And something, even now, it's even clearer. The need to make this information available to citizens has become more compelling by reason of the Right to Information Act. Now, a citizen of Ghana has the right to participate in the governance of a country. That includes knowing how the EC conducts its processes, conducts elections, and what have you. And in doing so, in order to have that critical input into governance, that citizen needs information. And the way to have that information is for the EC to provide that information. So I think because it's not only political, it's not only the candidates on election who may file an election petition, but citizens also could do that. It is necessary that the EC, for example, finds a way of making the pink sheets and the collation reports generally available and accessible to the public. So anybody who wants to be able to analyze them could go ahead and do so.
Right.
And if the EC were to refuse, I think somebody could do a right to information action.
Yeah.
To compel the EC to do that.
Yes, but if you did a right to information action, and minimum you are looking at 14 days within which they will supply you the information, and that will be you make the application after the results have been declared, and you have 21 days within which to go to the court. So should we not rather be looking at a legislative way where the EC is bound in the same way the EC tells us today that by CI 91 regulation 27 it is bound to publish the voters register, so that it will publish the pink sheets as well?
I agree with you. I agree with you. The easiest way, the point of least resistance, to do this is to require the EC to do that.
All right.
Just like the public election regulation require the EC to publish the provisional register on its website. Something similar could be done.
Ought to be done. All right. So thanks, Charles. Your suggestion clearly favors the individual citizen who the law expects to be the one to initiate the suits. This is the law, and this is your legal light and health law. We just try to give you pure legal education for your private and even beyond that, your civic use. And thank you very much. Dr. Abdul Basit is the one assisting us with this education on your multi-TV. If you have any questions, we welcome them, and we are receiving your questions at this time. If you have any questions, just bring them to us, and we will help you to appreciate the situation as far as this is concerned. Now, if the court has come to the realization that 8 months cost us a lot, and therefore we should cut to 42 days, will the court have a role to play in ensuring that once the results, when it says the date of the declaration, is it the time when it is gazetted, or just when the EC has come to TV and announced to us that this is the president-elect?
A presidential election, it is when the EC has issued an instrument under the hand and seal of the chairperson of the EC. Once that is published, then the declaration is done. So the 21 days begin to run from that date.
Okay. And I'm asking because we know that the results have to be gazetted. And the last elections, we know there have even been problems as to when it has to be gazetted, and it took so long a time until it got gazetted. So it is not the date from which it gets gazetted,
no,
but the date when the EC declares.
It makes a declaration, and that declaration is not just declaring on TV,
all right,
but it should be by way of an instrument.
All right.
An instrument. Usually, I think they call it the president-elect instrument. So once that instrument is published, then the 21 days begin to run from that date.
Okay. We have just infirmary. Yes, please, let's hear you quickly. We have just a minute to go. Hello.
Yes, please go ahead. Okay, too bad. He can't hear us. So, Dr. Abdul Basit Aziz Bamba, a senior lecturer at the University of Ghana Law School who has been assisting us. What will be your concluding comments on the whole issue of election disputes and how to manage them in such a way that we have a peaceful process?
I think it's important that we find very expeditious means of addressing and dealing with election petitions, especially when it relates to the president of a country. Look, it is sometimes some of the problems we have aren't necessarily legal, but in terms with psychological, economic, and social, because many investors would not like to invest in a country when there's uncertainty about whether or not the current president will be the president in the next 6 or 7 or 8 months. So we need to deal with election petitions with this part. But at the same time, it's also important that all the procedural rules that we have in place for election petitions are followed. And now everybody is given the opportunity to present his or her case. And the court also have to be given the time really to respond to the arguments that have been raised by the parties. You know, in election petitions, sometimes because of the emotions, the politics and everything involved, it's often an opportunity for the courts to indicate that they have comprehensively tackled all the arguments of the party. What you don't want is you hear, I made 10 arguments before the court. All that the court said was, after carefully examining your arguments, your case has no merit.
Yeah.
Many lawyers are very unhappy when they hear such. So I think, particularly in election petitions, we need to make sure we give very reasoned opinions for
Thank you. Thank you so very much indeed. Dr. Abdul Basit Aziz Bamba is a senior lecturer at the University of Ghana Law School and assisting us for the second time on this law show. I'm very grateful to you, sir. And thank you for all of you who joined us, Charles Asante, all of you out there watching your lines in there. Thank you all for joining us. Join us again next week for another exciting edition of the Law Show.